Hello everyone, welcome to today's Women in Sectional Title webinar. It's really great to be able to share this growing platform with you all, and our thanks must always go to our sponsors, ZDFin, CIA, BCMTrac, MeetingPal, Sectional Title Solutions, and WeconnectU. And please do yourselves a favor, go onto our videos page and just have a look at our sectional title sound bites, which give you a bit of an idea when I interview a couple of our sponsors. So thank you again. Here at Women in Sectional Title, we've been wondering how you ladies are actually doing. You know what, with load shedding, we've got all sorts of problems, and the flooding and war in the Ukraine. I mean, it's all really very overwhelming and can actually be quite negative. So we just wanted to say to you, you know, hang in there. If there's anybody who really feels as though they need advice or need assistance, you can always reach out on this platform to me or any of the committee members. So today, just to cheer you up, we've got a 3-2-1 Thursday. What's 3-2-1 Thursday? We've got 3 special treats. We've got 2 questions and 1 presentation. So the 3 special treats, Natal ladies in KwaZulu-Natal, we've been especially thinking about you. So we'd like to say the first 3 ladies in Natal who send me an email today after this, we'll receive a special treat from us, and we'll post some photographs afterwards. We really want you to feel as though you guys are not alone out there. 2 questions. When was the last time you did something for the first time? And the second question is, when was the last time that you felt a sense of wonder or sense of awe? You know, I think you've got the weekend to stew over those questions, and hopefully that will also uplift you a little bit and make you think about becoming a little bit more playful. We've all become quite serious. And of course, the last thing we've got to do today, which is really why you're all here, is the presentation on a couple of adjudication awards, which I have thought would interest you. And we're going to be discussing what's hot in the news and a couple of these adjudication awards. So a couple of things, these are the headings of each matter I'm going to discuss. So let's get right into it. Trustees' breach of fiduciary duty. Of course, we know fiduciary duty is that care and skill and diligence that the trustees have got to show. And we're going to look at an adjudication order about that. Corporate forced to provide documentation to owner, and adjudicators have no power to dismiss trustees or managing agent. We'll look into that. An interesting one about discrimination against cats. Maintenance woes, owner up in arms. We can also look into a retirement village who was forced to completely review the calculation of a vacancy factor levy. You'll find that pretty interesting. For special meeting to bring trustees into line. And also we're going to look at short-term rentals, beware of irregular and illegal rule changes.
Hello.
Okay, so first of all, we're looking at the trustees' breach of fiduciary duty. We've got quite a few to get through, so I'm going to go first. This is the matter of Guy Ellis and Coloretto Body Corporate. And this was a matter that was heard in, it was a body corporate in Hyde Park, and we had a couple of dealings with it as well. So throughout, by the way, this is going to be available. A recording of this will also be available. So we can even send you a hard copy if you'd like to send me a message and get a hard copy. So here, through 2015, 16 and 17, Guy Ellis that there were blockages in the common property drainage system that affected the drainage in the unit. The damage was caused to flooring, carpets, cupboards, wooden window frames, furniture. There was a terrible smell. And Ellis was actually really very good in putting together evidence of all the voice recordings, expert notices, and photographs, etc. And he said that the body corporate trustees had breached their fiduciary duties in the following respect. Firstly, by not acting at all times in the best interests of the body corporate, failing to ensure that adequate insurance cover was in place, failing to maintain the scheme effectively, to manage the scheme effectively, and failing to address the material issues of these blocked drains, and failing to reimburse Ellis for damages. So now the adjudicator in this matter, just bear in mind that in all of these cases, if you do find that the trustees are in breach of your fiduciary duty, you can carry on and actually hold those trustees personally liable. So this was quite a big case, and the adjudicator ordered that you had to form a link between the respondent's conduct, the body corporate's conduct, and the damages suffered by the applicants. And the body corporate had only acted in a reactive manner. They hadn't actually gone through, looked into it properly, given consideration to everything. And yeah, that was a big problem on their part. So Ellis had discharged the burden to prove damages. And that's what the adjudicator held. But obviously at adjudication level, you can't hear a claim for damages, right? It's only in terms of Section 39, those are of the Community Scheme Ombuds Service Act. Those are the only things that you can actually ask for in an adjudication hearing. So a damages claim would have to then go to court. All right, legal fees. There was no evidence about legal fees, so they said no claim. And consequential damages, the adjudicator was not empowered to make that award. Okay, right, so then the next case that we've got here, let me just minimize this one for you. Sorry, let me just go there. Right, in this case, it's a Theodore Kleinhans and Parkel Body Corporate, and this was dealing with documentation, and body corporate needs to hand over and provide documents to owner. So Theodore Kleinhans was actually really, really upset with both the trustees and with the body corporate for allowing certain things and for disallowing certain things. And he said that the body corporate and the managing agent also, was gunning towards the managing agent, and said that the managing agent was unable and unwilling to actually implement the Sectional Title Schemes Management Act. The chairman was not being corrected by the managing agent. And the managing agent actively sided with the trustees to the detriment of the body corporate and withheld information from one of the trustees. So, I mean, that just tells you quite a lot about this guy. He was really getting quite aggressive about it. Also, he went on to submit that the entire board of trustees must be removed without further ado, and that new trustees must be elected, because he said there were no trustees meetings held, no chairperson was ever elected, there were no resolutions, lack of knowledge. They utilized the caretaker for personal action. So I'm wondering if you guys are starting to feel that this is maybe somebody quite familiar to you who might be moaning. But actually, if you look at this award and the evidence in this award, Kleinhans really, really did have quite a good case. He wanted the documentation as well, which this is becoming an increasingly problematic issue, that bodies corporate are not handing over documents. And you have to, you've got an obligation in terms of the Sectional Titles Act to hand over obligation. And moreover, you've got that obligation to do so within certain time periods, 10 days with normal documents and 5 days with things like rules. So the adjudicator found that the body corporate was compelled to supply Kleinhans with all the requested documentation in terms of Section 39(7) of the CSOS Act, and that there was no jurisdiction, though, to remove managing agents, and there was no jurisdiction to remove the trustees, because, again, obviously, the Community Scheme Ombuds Service can only do certain things. They can't exceed their powers, and they certainly can't be removing people. They can, though, make an order, and maybe in this case, I think they should have made an order to take this kind of decision back to a special general meeting, so that people who knew what had happened at this adjudication hearing were given the opportunity to then decide for themselves whether or not they still wanted the managing agent or not. Okay. Right, this is an interesting one, and one you'll hear often. Isaac Daniel van Niekerk and Island Gardens Body Corporate. So in this case, we're talking about discrimination against cats. And what happened here, and I've actually just had someone on the phone this morning about exactly the situation. So in this complex, the conduct rules here stipulated that dogs were allowed under certain conditions, but not cats. The Niekerk wanted the rule amended on the basis that the rule discriminates against cats and the owner's constitutional rights. And reference was made to Section 10.3 of the Sectional Title Schemes Management Act, which states that rules must be reasonable and must apply equally to all owners. So basically, this adjudicator held that if we can apply rules around discrimination to people, why shouldn't we apply them to pets? And the body corporate brought evidence to the evidence that the body corporate brought was to the effect that complaints were received about the cats. So, for example, that they entered units uninvited, they climbed on the bed of a child who was allergic to cats, they would also eat food of other pets and generally make a nuisance of themselves. And we all know that argument. In fact, there was a lady I was speaking to on the phone, because we've got an 82-year-old who lives in a complex retirement village who wants to keep a cat, a feral cat. And the lady said, look, they wander around, they go into different people's units, it's an open plan. They really become a nightmare. I've also heard about cats that sit on cars and actually scratch the cars. So whilst you and I might think that there's a difference between dogs and cats, easier to keep dogs, this adjudicator found that the use and enjoyment of a section by a cat-loving person was detrimentally affected by the blanket ban on cats. The rule was unreasonable and not of equal application, therefore it must be set aside. And this is a truly emotional issue. It draws a lot of attention and it draws a lot of strong feelings. I wanted to just address with you what's happening in Australia about pets, because it's pretty interesting. We need to watch what's going on with trends around the world. So in New South Wales, the New South Wales government actually commissioned a public report on the issues of pets in strata title buildings. And the highlights of that New South Wales Department of Fair Trading's report, which is called Review of the Keeping of Animals in Strata, was based on a couple of things. They didn't just decide, a few people decide what must be in this report. Let me read to you who they brought into this. Animal Care Australia, RSPP New South Wales, Cat Protection Society of New South Wales, Women's Legal Service New South Wales, Owners Corporation Network, and your Western Sydney University Institute and New South Wales Young Lawyers Committee. So there are a lot of people who got involved. Quite a few heavyweights got involved in this finding. Basically, the gist of it, they said that comparing the health benefits pets bring to people against the allergic impacts on other residents means it would be difficult to justify allowing allergies to be a basis for refusing pet approval. They also said that they needed to look at a different specialized and less formal process for resolving pet or animal disputes rather than using the existing adversarial strata dispute mechanisms. And the trend all over the world at the moment is to make it easier for sectional title buildings, strata title buildings, condominiums to actually keep pets, but by placing bigger conditions more stringent conditions on this. So I'm not sure what you guys think of it. There's a case called the Cooper's case. You guys can look it up. It's a New South Wales Court of Appeal decision, which has actually started this trend of making it a lot more difficult to prohibit pets. Whereas now we can basically say we no cats and dogs. I think that's going to change. So get ready for it, managing agents. Right, here, owner was up in arms. And the case is Lloyd, Monday, and Spruit Park Body Corporate. And let's see why. So Monday owned 5 units in this specific body corporate. He alleged that 5 of his units had broken windows which had not been attended to by the body corporate. There was leakage on the roof due to poor maintenance and workmanship. The outside of the wall of the building had been neglected. Now, this was a huge complex, and it was run by a chairman and a secretary, 500 units. Imagine that. Very, very dangerous, I think, without a managing agent. If there are any trustees out there listening, my view is seriously that it's very dangerous to run such a big building or any building unless it's 10 units or less without a managing agent. All right, so his main gripe was that there was no communication from the trustees, no maintenance, repair and replacement plan, and he wanted lots of income damages claim of 87,300 because he couldn't procure new tenants due to his broken windows and a dysfunctional lift. It was quite interesting here. I just thought to note that actually Monday had been a trustee during the time all these problems that he complained about were never resolved. And the issue of the broken lifts was also during his time. So what did the adjudicator actually order? Well, firstly, the claim for loss of income was rejected because this is not the forum. Secondly, the body corporate was to request all owners' email addresses within 14 days for communication purposes. The body corporate was to call an AGM at which a maintenance, repair and replacement plan was to be presented. And the body corporate needed to call a special general meeting within 13 days to discuss the repair and maintenance of windows, which costs would be split 50-50 between the owners and the body corporate. And the award, the actual adjudication award, was to be shared with all the members of the body corporate within 14 days. So again, you're seeing a lot of the adjudicators, what they're trying to do is just take things back to meetings and press for decision-making at meetings, which is not a bad thing, because then if you don't get the quorum, then you make those decisions anyway. But this does seem to be an increasing problem or an increased worry. Okay, so this adjudication award now is dealing with a vacancy levy at Max Haven Retirement Home. So Max Haven Retirement Home is one of the Flower Foundation homes, and Michael G. House brought the matter to the Ombud due to the fact that he was very worried about a vacancy factor when calculating levy increments. And he instructed the Flower Foundation to refund the residents money related to this vacancy factor. So what it is if there's a vacancy in the Flower Foundation retirement village, where you may be required, you may be required to pay a portion of that neighbor's levy should the neighbor pass away, and it's sort of added on and placed into the monthly levies and worked out on an annual basis. So the retirement home, under these circumstances, submitted that the principle of a vacancy factor is well established in the retirement village industry, and that they've been using it now for the last 10 years. They submitted that the annual financial statements were published on the website and budgets were available for perusal at the manager's office. But now with retirement villages, you've also got to be very, very careful, because you're dealing with the Older Persons Act 13 of 2006, as well as the Housing Development Schemes for Retired Persons Act 65 of 1988, and they're clauses which actually fully protect older people. And Section 16 of the Older Persons Act says older persons have the right to be informed about the financial status of the residential facility. Section 4.1 says, and that's of the housing development RP, says a contract where the seller is the developer must include a schedule of all expenditure for the control, management and administration of the housing development scheme, and a statement that over and above any levy contemplated, the purchaser will not be liable for the payment of any such expenditure. Now, the adjudicator in this case was actually quite a brave guy, because at the end of the day, the adjudicator found it unfair on residents to experience a 9.5 per annum increase in the last 2 years, when the normal increase was actually linked to the CPI. And the adjudicator said that he was not convinced that the retirement home was correct in asserting that the application of a vacancy factor is standard practice at all retirement villages in the industry. So that's quite a good warning to all of us to say, you know, actually, these things can't just become an industry norm or a standard norm. And you've got to really exercise a cautionary approach when you're dealing with retirement villages in sectional title. And we know that a lot of villages are retirement villages under the Sectional Titles Schemes Management Act. So the adjudicator landed up ordering that the retirement home should cease increasing the levies of the residents, and the increase had to be credited to the unit for that for the year 2018 to 2019. So that was, I felt, a very, very brave award. I just wanted to see here. I see from Helen Marshall says, just as a question here, just going back to the pet thing, with residents working from home, we've had more and more complaints regarding dogs barking and cats being a nuisance. It's very difficult to manage and find an amicable solution for both parties. Yeah, Helen, I think you're 100% right. No doubt about it. So on our desks at the moment, a lot of issues. But what we do find useful is that there is some sort of internal mediation before you start taking things to CSOS, or you might even get an outside mediator to come in and to start really engaging with people where there are nuisances. Also, are the conduct rules in order, the conduct rules in place properly, not just a very vague and general thing on pets. You need to give really important information. And if I can go back, just sorry, that New South Wales thing for pets is a huge issue. They found, the finding of that report was also that there are 10 circumstances where it would be reasonable to not permit a pet to reside in a strata title which are embodied in certain findings. So they should, what that says is they should be able to impose reasonable conditions on keeping pets. And they say that there's no evidence that living in strata buildings is bad for pets, and you know the benefits outweigh the negativity. But their bylaws are very strict. I know that when I went to Australia, their bylaws are hectically strict. So maybe we need to look at reviewing something here through the CSOS. Okay, let me just go to my next slide isn't moving. So there we go. Okay, sorry. All right, the next one here is a forced special general meeting to bring trustees into line. And I think sometimes a lot of the managing agents or portfolio managers on this webinar understand what it means to try and bring trustees into line. Here we've got the applicant who was Nkuna, the Nkuna Family Trust, and the trustees of the body corporate of Westwood Gardens. Okay, so let's see here. Nkuna sought an order calling a special general meeting for the members to deal with specific business. He said that there'd been no annual general meeting in the complex since 2014, which was a number of years. He'd requested meetings to be held. He said the complex management was in a complete disarray and the attempted appointment of various managing agents had been a shambles. The trustees of the body corporate didn't arrive at the adjudication hearing, and nor did they arrange for anyone to represent them. So Nkuna led the evidence. Just for any of you who haven't been to an adjudication at CSOS, if the one party doesn't arrive, the respondent usually, if the respondent doesn't arrive, the adjudicator has every right to proceed with the adjudication hearing, most especially if they are absolutely convinced that that respondent has received notification and knows that that meeting was held. So the adjudicator will just let the applicant lead the evidence and an award can still be made. That's very important to know. Okay, so the adjudicator under these circumstances found that Nkuna was a very good witness and he had no reason to disbelieve Nkuna's version. So again, here, look what's happened. The adjudicator ordered that the body corporate by no later than the 15th of November, call a special general meeting of its members to deal with the following issues: management of the complex, role of the managing agents, service provider contracts, future general meetings of members. And the body corporate was compelled to furnish Nkuna with the audited financial statements, which was really, really important. Okay. Okay, this is one of the latest ones here as well, 2021, and we heard all about it now in January 2022. Short-term rentals, and this is when this matter came out, actually, 2022. Beware of irregular rule changes, and I think you'll all have heard of this matter, and it's definitely like a locus classicus at the moment, but it might be a little bit confusing, and that's why I really, really wanted to try and deal with it today. So the case is between Belinda Chela and 84 others in the Blyde Riverwalk Estate Homeowners Association, and the respondents were Blyde Riverwalk Homeowners Association, Baldwin Properties, and Lansdowne Property Group. Okay, so here the owners buying into the estate were subject to the rule that they could place their flats on short-term letting platforms for occupation by weekend and holiday guests. So when an owner bought, many of the owners here said that the only reason that they bought into this place was because of the fact that they could short-term let. The trustees and the developers then started alleging that short-term visitors contravened all the rules and showed no respect for full-time residents, security staff, and estate management. So what they did is they called a meeting, they amended the rules to impose more stringent terms and conditions on short-term letting. The new rule was passed with 53% vote instead of the 75%. So we know when we're amending rules, when you're amending your conduct rules, you need a 75% resolution. When you're amending your management rules, you need a unanimous resolution, which is a quorum of 80% and then unanimity out of that quorum. So what actually happened here is I think what the developer realized that they had made an error in making those rules so all-inclusive. And when they realized that, they decided they better backtrack. And that was really where the adjudicator had a problem on the backtracking. And I want to just go through what the adjudicator ordered. Okay, number one, the vote percentage was inadequate. The vote percentage, well, we know that, and I agree with that. He said there was not enough evidence to show that all the nuisance caused in the scheme could be blamed on short-term guests. There was not enough evidence to show that all the nuisance could be blamed on short-term guests. But this is the real crux of it, and this is what has been concerning people. He said, according to the Constitution, each owner has property rights which should not be interfered with. Such property rights come with the ability to generate wealth and income. Okay, so what does that mean? Does that mean that every time you go to the community scheme ombud service to try and scrap a prohibition rule on short-term letting, that they're going to say, well, actually, a person has the right to generate wealth and income? I don't think so. If you remember, there was a very important case called the Paddock and Sally Nicol, where Sally Nicol wanted to short-term let, and the body corporate won the case against her because there was a proper rule in place which prohibited short-term letting. This adjudication order in no way supersedes the Sally Ann Nicol case. In my view, you would still be allowed to put a rule in place which states that no short-term letting is allowed. And I think that would be upheld. I think here you've got a situation where the rule wasn't changed properly, and that's really what the problem was. If that rule had been changed properly, if that had evidence to show that the nuisance caused in the scheme could be blamed on those short-term letting guests, I think you would have had a very different award. So I think that we need to be really, really mindful about that. That's the crux of the matter. I just wanted to find out at this point in time if there are any questions about any of these, I'd like to open things up to you guys in terms of any questions. I'm going to just any questions? And now I wanted to just also discuss two things which I have picked up in the course of all these CSOS adjudications and awards, which might be useful to you. Anybody with a question? Just unmute yourself. No. Not at this stage. Okay, then there will be time for questions at the end. Those are basically the cases that I've had a look at. I know that at the end of the day, the CSOS does seem to be moving a little bit quicker, in my view. I think things are starting to get a little bit better at the CSOS. But there are two things, and there are two cases that I wanted to raise with you. Oh, sorry, Helen just said she wanted to know about the 75% resolution. If the 75% resolution, well, it depends. If you're doing like a round robin 75% special resolution, then you don't need to have everybody at the meeting. You can do 75% of all owners. But if you're having a special meeting and you need a special resolution in number and value, then you're going to need to definitely have that special resolution based on getting a quorum and then a 75% of the people there, of the quorum at the meeting. I think what happened with that meeting, by the way, was that a quorum was there at the beginning and then they dropped off, people dropped off, and because it was an online meeting, it was like a hybrid meeting, so people dropped off, so they didn't actually have the quorum. And I think that was also where the problems came in. Let's just see. Madeline, hi Madeline. Why would CSOS approve conduct rules that do not allow cats? Again, you know, this whole thing was the case that we had was quite discriminatory because they already allowed dogs. So you can't discriminate and allow parrots and not cats, and cats and not dogs. I think that's what the bottom line was. But yeah, at the end of the day, there are a lot of reasons. People are sometimes just don't enjoy cats, and it's, as we said, it's the whole allergy thing. It's the wandering around. A friend of mine actually owns a unit. He owns a cat, and at the end of the day, he just gets rude messages all day long from another owner in the building, where his cat just visits them all the time. All day, just seems to like that particular unit. So what do you do? I'm not sure. Alrina says, our rules state that all pets should be sterilized, but one owner didn't adhere to the rules. Well, yeah, there's always owners that don't adhere. They breed with dogs, advertise the puppies on the informal chat group. As trustees, we can have the puppies removed and pets not sterilized removed. Well, yeah, look, at the end of the day, I think you would have that option, to be honest, because people are not adhering to the rules. And what I'm finding as well, more and more, is that you can't make exceptions. The minute you start making exceptions in these buildings, you know, you just can't get anywhere. Anyway, I just wanted to carry on to say to you, the courts, our courts are getting very sticky about taking community scheme ombud services matters to them. So, you know, people are really, really becoming a little bit, well, the judges certainly are becoming very wary of giving high court orders where the matter should have gone to the ombud. And whilst the High Court does have what we call concurrent jurisdiction to hear a matter, they can hear it. Sometimes they actually don't want to hear the matters. And there's a case called Heathrow versus Manhattan Body Corporate, and also a Western Cape case. And in this Heathrow case, the court set out this position, and I wanted you to hear this. By establishing the community scheme ombud service, whose personnel is required to consist of suitably qualified adjudicators, the legislator had intended that the CSOS be the primary forum for the adjudication and resolution of disputes in matters such as the present. The court went on to state that a court is not only entitled to decline to entertain such matters as a forum of first instance, but may in fact be obliged to do so. Such matters will not be matters which are properly before the High Court, and the court is accordingly entitled to decline to hear them. So yeah, I think that's one of the things that we've got. Then in the latest case, which was now in January 2022, it's called Wingate. It was the Wingate Body Corporate. This is also on the same point. The judge said, it is apparent from the authority cited in this judgment that the nature of disputes in this matter falls squarely within the ambit of adjudication by the Community Scheme Ombud Service. The argument that the applicant was entitled to bring these proceedings to court because it can, falls in the face of the authority cited above. The applicant has clearly circumvented the mandatory adjudication process of the Community Scheme Ombud Service. I consequently decline to entertain the matter. So that was a judge, that was the judge in this case. So as attorneys, we've also got to be very careful that we don't push people to go to the High Court very easily, because they'll just push it back. I know what you're thinking. The problem is CSOS needs to be up to speed, because if you can't get a hearing within 3 or 4 months, or, you know, it goes on and on and on, where is the justice in that? I mean, where do you get your justice? So that could be one of the points you raise if you take a case to court and say, look, well, the CSOS is taking too long, or they're insufficiently staffed or resourced to take a matter to CSOS. That also becomes an issue. The other thing I wanted to talk to you about was your clients or managing agents, or if trustees are listening here today. I'm finding more and more CSOS awards are just dismissing people's claims because they're not asking for the right things. They're not asking for the right things. At the end of the day, we had a lady who came to us from one of the big complexes here in Gauteng. She was an applicant who thought she understood the law. She put together a 300-page application to go to the Community Scheme Ombud Service. And most of it was nonsense. Most of it didn't deal with what Section 39 of the Community Scheme Ombud Service allows you to deal with. Behavioral issues, corporate governance issues, replacing of rules issues. There's certain things where you really, really can't ask the CSOS for, you know, to change or amend or do certain things. So my advice is that certainly to clients, and I'm talking about the more complicated matters, to advise them to get advice, whatever kind of advice, either legal advice or from a more experienced managing agent, to how to put together a claim to go to CSOS. Because whilst everything is perfect and, you know, whilst you've got a claim, you've got a case, the way that you put it across is really vital. Also, adjudicators at CSOS, we're going to be approaching the Adjudicator General at CSOS to say we need more training for the adjudicators at CSOS, because whilst there are many very good adjudicators, there are a lot of them who don't have a clue about sectional title, and that's a very big concern for me. It really is, because at the end of the day, there's certain things that are just basic that are being ignored. And we need to get to a point where we're confident to hand over these kind of matters to the Community Scheme Ombud Service, who are providing, you know, justice. Baba Lillian, I see you left. You know, justice to all, and that's what we're wanting. So, if there are any comments about that, I know that one of my colleagues, Zelinda, is also making a lot of attempts to push for better service and better quality of service. I think at the same time, and I think that's great, we also just need to work together with the Community Scheme Ombud Service and assist them, and maybe provide the training or whatever that is necessary to get this back up to speed. I can also tell you pretty good news is that women in sectional title have taken a stand at the NAMA in Indaba, which is in October this year. And for all of you, if you guys haven't been to the NAMA in Indaba, please do try to come. It's so worthwhile. You'll see really good speakers. You'll see exhibitions, you'll see stands that are important in our industry. Just keeps you up to date with things, makes you become more professional, and also makes you feel as though you're part of a bigger group. And I think that's bodes well for all of us in this industry. Okay, I think I'm going to try to answer the questions that you guys have put up. I'll send you the questions. Please, if you're from Natal, we're offering you something special from Women in Sectional Title. The first 3 ladies who emailed me, I'm going to have a look as soon as I'm finished this to see who you are. And we wish you the best of luck. We wish you good luck with everything. Is there anybody who'd like to unmute themselves and ask a question? I'd like to see anybody who's here. I see we've had a very good response. Lots of people have said they're offline because of load shedding. Okay, but if that's it, I think we've gone through things pretty quickly. I think things are quite simple today. But if there are any questions or if you've got any other interesting Ombud awards that you'd like me to present, it's great for you guys to be able to keep these Ombud awards on your desktop. That's what I do. Anything that comes up, I'll keep. So if a trustee phones me or asks me, like happened this morning, you know, it came up and I was able to answer. There's a question there, Carolyn Mersich. Just unmute yourself.
Morning, Marina. Marina, I just wanted to find out just with
Caroline.
Can you hear me now?
Caroline, can you hear me?
I can hear you. Can you not hear me?
Yes, I can.
Okay. Hi, Marina. Marina, just with regards to the CSOS adjudication process and orders, and obviously the only recourse that applicants have or respondents have is to go to High Court where they are not in agreement with an adjudication order, where there have been errors in law, etc. There was discussion at CSOS at some point about implementing an internal review or appeal process at the CSOS, which I think is a good idea because, you know, telling clients that they need to, or applicants that they need to go to High Court defeats the purpose of the CSOS being a cost-effective mechanism for dispute resolution. So is that something that you see that will be implemented hopefully within the near future at all?
Yes, absolutely. Great question. Thanks, Caroline. Yeah, I do foresee it. I think that it's important because I think that there are things that can be reviewed, even if it's just a small error or something which somebody didn't pick up, or just somebody needs to, you know, make that adjudicator aware of internally without kind of being an embarrassment or whatever, where they can actually rectify an award. I think that is important because, again, we asked all day, every day, to take awards and have a look at them to see whether or not they're appealable. And some of them are definitely appealable and some of them are definitely not. But with the ones where we have to tell people, look, we're going on appeal, I mean, it's a huge decision to make, to go on appeal, because firstly, it's going to take you 2-3 years. You're going into the High Court, so now you're finished with CSOS. You know, CSOS got nothing to do with it anymore. Now you're going into the High Court. And again, as you say quite correctly, you know, what for? Why should you be going to the High Court and spending big money? I mean, a High Court appeal, you know, you're looking at between 40,000, 70,000 Rand up to there. So, you know, I don't know. Is it worth it? Then you've got to ask yourself, is it worth it? For some people it is. We do appeals, again, every day, all day. But I just think that the whole mediation thing for me needs to be worked on more. Internal mediations need to be worked on even before you go to CSOS. And I think that's where we can all play a role, just to try and get those internal mediation processes a little bit more streamlined so that people don't get so upset and just rush off to CSOS. So yeah, that's my tuppence worth. Anyway, we've come to the thank you, Caroline. Okay, we've come to the
no problem.
The end of today. Really appreciate you coming on board, and please do let me know what it is that you would like to hear. What kind of things interest you? Is it only legal things? Is it only, that type of thing? Or are there other things that are on your mind? Thank you, Heather. Thanks, everybody. Take care. Again, thank you, ZDFin, CIA, BCMTrac, MeetingPal, Sectional Title Solutions, and WeconnectU. We really appreciate your help and guidance and support, most of all. So we'll see you again soon. Thanks, everybody.